Hello everybody, welcome. Today we're going to look at another case. So this case is filed in the District Court for the Northern District of Texas for unreasonable delay in a case for naturalization for citizenship, so for N400. We're not going to look at the complaint itself, but we're going to look at the order of the court that was signed by the District Court judge. So this was for a petitioner who brings this action alleging, like I said, unreasonable delay by USCIS and for his naturalization. Naturalization meaning that he applied for citizenship for N400 form. And the respondent, which is USCIS, moves to take this case back, remand this case back to USCIS. So here is some background. So this person is a citizen of India and became a full permanent resident of the U.S. in 2017 pursuant to his employment by a U.S. employer. At the same time, he was a permanent resident. He married under U.S. citizen, I'm assuming, and then 21 months later, almost 2 years later, he divorced that person. In August 11th of 2020, USCIS issued a notice to appear. Notice to appear meaning it's not good. It's in removal proceedings, alleging that he had procured his permanent residency by marriage fraud. Again, they allege that, but as we read, he's saying that is not true. Then he appeared before the immigration court July 30th, 2021, and the immigration judge granted his motion to terminate the removal proceeding on the grounds that the DHS has failed to file any documents showing that there was any marriage fraud allegations. He filed an application for naturalization with the USCIS so look at these dates. So October 7th, 2022, right? Then there was an interview on May 4th, 2023. And this case was filed June 5th of 2024. Sometime after the interview, they notified that he had passed the English language and the U.S. history test, but an informal decision cannot be made yet about your application. He filed this lawsuit on March 5th of 2024, 10 months after his naturalization interview. So again, there's some questions about when can you file, these types of mandamus lawsuits, because you've seen in other lawsuits where they file it after a year of applying for a naturalization, but then you see other people that file it after their interview. But here he filed it 10 months after his naturalization interview, alleging that he still had not been notified of any decision on his application. So USCIS is required to issue a decision within 120 days of his interview. He asked that the court to either adjudicate the application, the court to do it and naturalize him, or in the alternative to send this case back to USCIS and have them do within 14 days. And bar USCIS from alleging marriage fraud. But he's saying that he maintains in his suit that his marriage was not fraudulent and that he had never gained lawful permanent residency through his marriage, but rather through his employer. He contends that the only effect his marriage had on the naturalization application that led to his lawful permanency was a benefit of greater visa availability based on his spouse's country of birth, a fact that he alleges was coincidental and not the intent behind their marriage. In any case, so here, under the INA, the Immigration Nationality Act, an applicant who seeks U.S. citizenship must satisfy several requirements. So we know this, but here are the requirements. So you have to be a legal permanent of the United States for 5 years. There's also the 3-year rule, which is not really mentioned here, but for 5 years, proficiency in the English language, understanding of the U.S. government, history and government, showing that is a person of good moral character. And he must also show that he has lawfully admitted to the U.S. for permanent residence. They only contest whether that he was lawfully admitted for permanent residence or whether he was obtained his permanency fraudulently via his marriage. Okay. So the court is saying if USCIS fails to adjudicate naturalization application within 120 days of the interview, then you can file a lawsuit. The applicant may apply to the U.S. District Court for the district in which the applicant resides. This is where he resides this is why he brought it in the Texas district for hearing on the matter. The 120-day period begins to run on the date of the naturalization interview. The vast majority of district courts remand lawsuits filed under the section to decide on the first instance whether to grant or deny an application for naturalization. The courts have noted that remand is often an adequate remedy because it does not wholesale foreclose judicial review of the plaintiff's application as following a remand. But there are certain situations in which the courts have elected to exercise their statutory authority to adjudicate the naturalization application. The few cases that the district court decided to adjudicate the naturalization application, it has been pending for a very long time, and the defendant failed to assure the court that a swift decision has been made on the remand. So basically, what they're saying is, the courts can take jurisdiction and naturalize you, but it's rare because it has to be pending for a very long time, and the respondents are not giving the courts the answer of when they would do it. The courts have usually concluded that delays egregiously lengthy such a remand will be inappropriate when 2 or more years have passed since the plaintiff naturalization interview and the USCIS has failed to provide the court with assurance as to when it will perform. So if it's more than 2 years after interview, the courts can take jurisdiction instead of sending it back. The court concludes that it should remand this matter to USCIS to adjudicate the application for the first instance. They're saying the respondents, USCIS, have provided a reasonable explanation for the delay in adjudicating his application, that the USCIS needs to resolve. The reason is because the USCIS needs to resolve the marriage fraud issue. According to respondents, USCIS recently completed the necessary analysis of the marriage fraud issue and is now prepared to issue a prompt decision on the application after advising of the adverse evidence and affording an opportunity to submit a rebuttal evidence. Second, the delaying case has not been linked. The court is saying that only 10 months have elapsed since the naturalization interview, and the respondents have committed the U.S. will adjudicate his application within 60 days. So although they're saying that 60 days is longer than what they wanted in terms of 40 days, this length of time is appropriate. So basically, the court is sending it back to USCIS. Again, regarding the mandamus, so the court is saying that an enforcing order under the Mandamus Act may issue only when there are a couple of elements. The plaintiff has clear right to relief, the defendant has a clear duty to act, and number 3, no other adequate remedy exists. Even if all 3 elements satisfy, the court has a discretion to grant or deny writ of mandamus because of extraordinary nature of the remedy. Because the court has jurisdiction over this case, and because the provision provides a remedy for unlawful delay agency in this naturalization, mandamus is not a necessary relief. The court is saying that it cannot satisfy the 3rd element required for to issue an enforcing order under the Mandamus Act. Therefore, that is denied. And also, he's seeking attorney's fees, but in order to win that, what the court says, there are 3 elements. A litigant who has brought a civil suit against the U.S. is entitled to attorney's fees and costs if he prevails in the party in the matter. The government fails to show that his position was substantially justified or special circumstances make awarding just and the reasonable fee costs are reasonable. The court is saying in order to become permanent, only once his naturalization application has been adjudicated. Because the application has not been adjudicated, he has to request for attorney's fees and costs. I mean, in a majority of these mandamus lawsuits, there is no attorney's fees that are awarded because you're not going to win. You're not going to be able to meet these different elements, and so there's no attorney's fees that are ever awarded. For these reasons, the court remand this matter to USCIS in order to USCIS adjudicate his applications within 60 days. And the court retains jurisdiction to ensure that the USCIS complies with the judgment and decision. Again, you don't know which type of decision he's going to get, but some type of decision, right? Within 6 days, that's what the court is ordering. All right, everybody. If you like this, give me a thumbs up, like, subscribe, so that help more people find this channel. Thank you very much for your time. Thanks. Bye.